As Nathan said, we serve 44 counties in Arkansas. We have a little map on this presentation that shows you where our offices are. These are all of the counties we serve, the ones in pink. And we have offices in Fort Smith, Russellville, Little Rock, Hot Springs, El Dorado, and Pine Bluff. You can visit arlegalservices.org/apply online if you want to apply online, or you can call the helpline at 800-950-5817. So the services we provide are housing law, family law, debt, bankruptcy, veterans, consumer law, public benefits, end-of-life planning, disaster services, criminal record sealing. Pretty much the only things we don't do are criminal law outside of record sealing, and we don't do any like injury or anything like that, any personal injury. So we have disaster specific services. My position is funded by a grant to help the victims of the 2019 Arkansas River flood. If you were impacted in any way at all and you have a current legal issue, it doesn't even have to necessarily stem from the flood. You can give us a call and I would love to talk to you. We are also helping people who are affected by COVID-19, especially evictions. That's a big issue right now. So today we're going to talk about consumer law, which includes scams, debt collection, foreclosure, bankruptcy, and rent to own, or contract in lieu of deed. It's just a way to buy property. I'm also going to talk about housing law, like renters' rights and responsibilities, warranty of habitability, which means whether or not your house is safe and secure and healthy, fair housing issues, self-help evictions, which we're actually seeing become a problem nowadays, and the CARES Act. So consumer law. Common scams. There are no government programs that help you pay your bills in exchange for payment. You may have heard of programs where the government does help you pay your bills, but they're not going to ask you for payment. It's going to be a special grant. Another thing you have to watch out for is federal investigation emails, where you get a random email telling you to click a link. Don't click a link. If someone is claiming to be from the government, they're probably not going to reach out to you via email or social media. There are also renting scams, especially on Craigslist. I've seen this happen to people where they will look at pictures online and want to rent a place, and they wire the money, and it turns out the place never existed and their money is gone. A lot of times, a potential landlord on Craigslist will also ask you to give your personal information to do a background check before you've seen this house, before you've done any kind of application. They're just looking for your information. They're just phishing. Try not to give out your information when it's not necessary. Another scam that I have personally been impacted by is this IRS tax bill thing. Sometimes you'll get an email with a payment link and it'll say you owe the IRS however much money. You need to click on this link to pay us. Or they'll tell you to make out a check to the IRS. This is a scam. There's also a scam where you get a phone call and you're told that the IRS has a warrant out for your arrest. This has actually happened to me personally, and you should just do what I do and laugh at them because this is ridiculous. So some tips to protect yourself from scams. Beware of offers that seem too good to be true. You need to know, like I said, government agencies aren't going to contact you through email or social media, not initially anyway. Beware of websites that want you to sign up for a free service by providing your credit card or bank information. I've seen this happen with people looking for jobs. Used to be you could just walk on down to a shop and ask to put in an application or ask to speak to the owner, you know, looking for work that way. Now you have to go through things like LinkedIn and Glassdoor and Indeed. And sometimes you will be redirected to sites that just want your personal information. So it'll say, if you want to work for, we need your information. We need you to make an account. Don't do it. They're just fishing for your information. Another thing is to be aware that if a person or a business wants you to pay by gift card, prepaid debit card, or a wire transfer, that's probably just a way to get your money and you'll never see it again. For debt collection, to protect yourself, of course, you need to prioritize. You need to pay your rent first, utility second, medication third, food fourth. Probably after that is going to be your car. So just keep that in mind. Unsecured debts like credit cards, if you don't pay that, it goes into collections. You can be sued for that, but you won't lose your home necessarily. So if you don't pay your bills, the creditor may stop doing business with you. They can report you to a crediting reporting company and, you know, bring your credit score down. The creditor can call or write you to ask for payment. There's limits to this. We're going to talk about that in a minute. The creditor can also sue you in court, even if you are making partial payments. If you are being sued, this is very important. If you're being sued, you have a certain number of days to reply. If you're being sued for a medical bill, you have 30 days to answer and you don't answer. What will likely happen is a default judgment will be entered and the creditor will just start to garnish you. And at that point, there's not a lot you can do unless the creditor messed up somewhere along the way. So if you are sued, please contact an attorney as soon as you can. If you can't find an attorney, at least enter an answer, some type of answer to that lawsuit. Sometimes you just have to protect yourself, and ignoring the problem will always make it worse. You can also call and try to work out debt collection yourself. You can ask for a payment plan you can afford. They'll try to pressure you into something you can't afford. Just, you know, if you can't afford it, don't accept it. You can ask for a lower interest rate. If you are unemployed or affected by COVID or the disaster last year, you can ask to move missed payments to the end of the due date, or you can ask that they lower your payments. A lot of times debt collection places will be more helpful, or not even just debt collection, but if you're about to be behind on your car, call the financer and tell them what's going on. You can ask to change a due date. Say your insurance is due on the 16th, but you won't get another check until the 31st. You might ask if you can have that due date moved. And if there's an error and you're being charged something that you shouldn't be charged for, you need to tell the creditor immediately, and you need to tell them in writing. You need to keep a copy of that so that you have proof that you let them know that there was a problem. So there is something called the Fair Debt Collection Practices Act, and it protects people from unfair debt collection. Some of the things that a debt collector cannot do is they can't threaten you with violence or harm. They can't cuss at you. They can't lie about what you owe. They can't lie and say they're an attorney. They can't lie and say they're with the government. And they can't lie and say you'll be arrested. They can't deposit a post-dated check early. So if you have come to an agreement and you said, well, you can cash this check on the 16th for my payment, and then they go back and deposit it early, they can't do that. Unless you give permission, a debt collector cannot call you before 8 a.m. and after 9 p.m. That's something to keep in mind, because if you have debt collector calls, you want to make sure that they're not calling you all times of the night. They can't contact you at work if you tell them you're not allowed to take calls at work. They can't discuss debt with anyone but you or your spouse, if your spouse may be responsible for that debt. If let's say your mom owes a debt, they can't call you and talk to you about collecting it. They can call you once to ask about contact information for her, but they can't keep bothering you and asking you to pay it. And if you have an attorney, tell the debt collector and they can't contact you. They have to contact the attorney from then on. And that sometimes is enough to help alleviate some stress for people. So if you get a debt collection letter, within 30 days of that, you should write back and ask for validation of the debt. I would do that even if you remember incurring the debt. Go ahead and ask for this validation because there might be a mistake. If you have an attorney, tell the debt collector. Once again, the debt collector has to talk to your attorney. If you have a debt collector who is harassing you and you don't have the money to pay and you want them to leave you alone, you can send a letter to them asking them to leave you alone. You have to send it certified mail, return receipt requested. You can talk to someone at the post office about how to do that. You need to go ahead and keep a copy of it. After that, the debt collector can only contact you to say that they'll stop. They can contact you to say, well, we have a right to do this specific remedy, such as suing you. They can contact you to tell you if they take that specific remedy, like if they sue you. They can contact you for those things, but that's it. They can't keep calling asking for money once you've sent this letter. So moving on to foreclosure. Foreclosure is the legal process that allows the bank to sell your property if it's been mortgaged. This is something like debt collection that if you stay on it and try and ask for help, it might help you in the long run. When you first fall behind, explain the situation to your loan servicer and see if they can move your payment to the end or lower your payments. If you are 45 days behind, the loan servicer has to send you a loss mitigation application. Go ahead and fill it out and send it back. Even if you think you're going to pay soon or you don't think that any of the ways to help you are helpful, go ahead and send it back because down the road you might be happy you did. The bank can begin formal foreclosure 120 days after you miss a payment, so keep that in mind. So there are two kinds of foreclosure. There is judicial, which means it goes through a court, and non-judicial, which means it doesn't go through the court. And these are ways that the bank or the loan servicer can sell your home. In both cases, they have to give you something. They have to give you notice to let you know that your house is going to be foreclosed on. In the case of a judicial foreclosure, you'll be served with a summons and a complaint, just like if you're being sued. And you have 30 days to respond, just like with the being sued for a debt collection or for a debt collector. You have 30 days to respond. You should always respond. If you don't respond, or if you do respond and the judge doesn't rule in your favor, there will be a judgment entered and your home can be sold. For non-judicial, since you're not being sued through a court, you'll just get a notice of default and intention to sell, and that'll give you a sell date. Your home is going to be sold on that date unless you or your attorney do something about it. So once again, if any of these things happen, don't ignore it. Try and either call and work something out or try and find an attorney. So different ways you can avoid foreclosure includes temporary payment agreements to catch up, or a forbearance, which is just putting off your payments for a certain amount of time. This works a lot with student loans. If you're behind on student loans or unable to pay your full student loan payment, a forbearance may be available to you, and it'll just give you a month or two to try and catch up. There can also be permanent changes to your the terms of your loan, such as lower interest rates or longer payments. If you get a couple of payments moved to the end, that'll extend it. Or if you have a 20-year mortgage, they might want to change it to a 25 or something like that. A lot of times they'll be willing to work with you because they want their money more than they want your house. So if you are foreclosed upon, to get completely out from under the debt, the lender may agree to a short sale, which means that if you sell your house for less than you owe, they'll accept that money and not go after you for the rest of what you owe. There's also something called deed in lieu of foreclosure. And that is basically where the bank's telling you they're going to foreclose. You don't want to fight it. You can't fight it. There's nothing you can do. So you can agree to hand over your deed instead of going through the foreclosure process. And even though you'll still lose your home, this may keep your credit from being damaged any more than it has to be. So at the end of lots of debt, a lot of times the only answer is a bankruptcy. There are several different kinds. The main kinds that we usually see are Chapter 7 and Chapter 13. Chapter 7 is when you don't have a lot of income and you don't have a lot of property. So a lot of times this will just wipe out unsecured debt. If you have secured debt like a house or a car, as long as you're current on those payments, you might be able to keep those and not lose them through the bankruptcy. And Chapter 7 takes about 3 months. Chapter 13 is for people with more income and more property. And this is usually just restructured payments that they make for 3 to 5 years. And that takes longer, of course. So things that bankruptcy will not do: bankruptcy won't eliminate child support, eliminate alimony, it won't eliminate criminal fines, it won't apply to any debt that you've gotten since the bankruptcy. If you file for bankruptcy today and then tomorrow go and open a Chase credit card, that credit card will not be on the bankruptcy. In most cases, bankruptcy won't help you with taxes or student loans. Yeah. So now I'm going to move on. We're going to transition into housing. I'm going to talk about rent to own or contract for deed. And a lot of people choose this because they can't get approved for a mortgage. And everybody, not everybody, but a lot of people want to own a home. So a rent to own seems like a really good idea. I cannot recommend that you stay away from these enough. There's always a complication, and you're always, as the buyer, you're in danger of losing money, of losing your home. It's just not a good idea. If you do decide to do it, you should be aware the contract needs to have several things. You need to state what you're buying, whether you're buying the land or the home. Sometimes people misunderstand what's going on, and someone is rent to owning a trailer, but they're not buying the land, or they're buying the land and not the property. Like, you need to make sure all these things are written down in the contract. You need to note in the contract who pays taxes, who pays the insurance, who makes repairs on the home. You need to check court records to make sure that this person actually owns the property. You need to record the contract with the circuit clerk. You need to get all terms in writing for the purchase of a home or the purchase of land. You need to have it in writing, or it's not good. Oral contracts for land are no good. So make sure you always get it in writing. And of course, ask an attorney to review the contract just to see if you've missed anything or if there's any way you can make your contract protect you more. So what are some bad things about contract for deed? Well, if the seller loses the home, you lose the home. If you've been paying for 14 years and you're on your 15th year and they're foreclosed on, your money is probably gone. A lot of times there are balloon payments. Someone will do a 10-year rent to own, and at the end they have to come up with $30,000. A lot of people can't do that. So once you get to that balloon payment, they lose the home because the contract has been violated. Sometimes someone will miss a single payment, or they'll break the lease. This could mean that you lose the house, even if you're, like I said, 14 years into paying it, and you are late one time, you might lose everything. Of course, you can always sue for that money and try and get some of it back, but that means you have to go to court. That means you have to hire a lawyer. Once again, you're just out a lot of money. And then the worst part of rent to owns, there are actually things that work out to be scams if they didn't intend to be in the first place. The seller might charge a large down payment, say like $5,000, and then you move in. A month later, they evict you. You're not getting your $5,000 back. You'll have to fight for it. It'll cost you a lot of money. You'll probably lose more than you did in the first place. Sometimes the contract for land is so badly written that at the end of it, you do everything right and you've paid off the contract, but it didn't actually give you ownership rights at the end of the payment. That's something that can happen. Another thing that can happen is the seller just decides they don't want to sell to you anymore. You're friends, and then you're not getting along, and then they're like, I'm done with you. Once again, you have to go to court, try and straighten it all out. Another thing that can happen, and has happened, is that someone sells you a piece of land, and then they don't even have title to the property. It doesn't even belong to them. And that's why I said earlier to make sure you check land records and make sure they own that property. So now I'm going to talk about housing law, mostly landlord-tenant stuff. It's something we see a lot of, especially right now with the COVID-19 stuff, people losing their jobs, and yeah, it's happening. So renters' rights and responsibilities. You have right to sole possession. You have right to something called quiet enjoyment. Sometimes you have a right to a safe, habitable home. Most of the time in Arkansas, this is not the case. You have the right not to be discriminated against. You have the right not to be self-help evicted, or I'm going to talk about that a little bit later. Your responsibility as a tenant is to pay rent in full and on time, to not be a nuisance, to not damage the unit, and to not move people in and out without the landlord's permission. So some tips for renting a home. Okay, can you explain quiet enjoyment? Quiet enjoyment, it just means you can enjoy your property. It doesn't necessarily mean that your neighbors can't be loud, but it does mean that you have to have access to the home. You have to have a parking spot so you can get to it. If you are in an apartment and people are loud, usually there's a curfew for noise and people being loud after 10 o'clock, that can be a problem. Quiet enjoyment is just basically no one is keeping you from enjoying your home. This can be interpreted pretty broadly. I could try and argue that quiet enjoyment means having air conditioning. I mean, it's kind of loosey-goosey, but quiet enjoyment basically means the ability to just enjoy your home and use it. So tips for renting a home: always tour the unit. Always, especially if you're going off of Craigslist. Like I said before, tour the property. Don't give out personal information. Don't be wiring money before you've signed any lease. Another tip for renting a home is to get a written lease. A lot of times things that are written in the lease can protect you if you suddenly get evicted later. If there is no lease, you're just a 30-day, month-to-month tenant, and you could be evicted within 30 days without a reason. So it's usually good to have a written lease. When you move in, take dated photos and video because you never know what you're going to be accused of doing or messing up when you try to move out. Don't do any verbal side agreements. For example, one I see a lot is don't tell the landlord that you're going to fix up their property in return for a $200 discount on the rent. If you make a verbal agreement to that, speaking from experience, from seeing it happen to other people, in a couple of months, the landlord's going to want more money than what you're giving, and they're going to pretend like that agreement never existed. So get all agreements in writing. Watch for red flags in leases. A really big one would be if there's something that says you waive your right to a legal eviction, like don't sign that. If it's trying to get you to waive your rights, that's not good. You don't want to be there. Keep looking, move on. Don't sign with that landlord. And something really important in Arkansas, where your landlord doesn't have to repair anything and they can put you in a box and with no running water and it's fine. Look at the lease and see if there's anything about repairs. Who is responsible for repairs? Another thing I see a whole lot is people telling me that they went to rent a house. There was like a broken floor, broken cabinets. The landlord said, I'll fix it. And then they never fix it. Do not sign a lease until the repairs are made. And if you have to move in and the repairs aren't made, get the landlord to put on the lease that they have to make the repairs that they told you they would make. Otherwise, they're just not going to happen. This has happened to me personally. This happens to clients of mine all the time. Okay, so habitability is basically your home being healthy and clean and having AC, having running water. If your house has an issue with habitability, if you have bugs or holes in the floor or broken windows, broken AC, broken heat, broken stove, look at your lease first. See if your lease says who has to make those repairs. If you don't have a lease or the lease doesn't say anything, if you live in the city, there might be city codes that can help you out. Little Rock has city codes that do help people out sometimes. It's good to know, though, if you call the city on your landlord and the landlord decides to kick you out for that, there is no ban on that in Arkansas. Like, someone can actually go ahead and evict you for that. Like I said, under state law, there's no obligation for your home to be safe and sanitary, but you may be able to break your lease. Call us about that if under federal law, there's not any kind of habitability protections unless you're under federally funded housing. Like Section 8 has to have inspections and housing authority, things like that. So fair housing. What is fair housing? Fair housing is the right for everyone to live, buy, rent, whatever, where they wish, free of discrimination. The protected classes are race, color, religion, sex or gender, national origin, familial status, disability. Sometimes people who are victims of domestic violence are protected under this. And sometimes people with criminal histories are protected by this. Not very often, but sometimes. So the fair housing statutes protect you from landlords pretending that there's no units available, protects you from refusing to rent who you are. If you are a divorced woman and you're trying to rent and your landlord says no divorcees, well, that's a fair housing violation. If they have discriminatory terms and conditions, or advertising, or they refuse relocations if you're disabled. Okay, now who must follow the rules? Landlords with more than 4 units. So if you're renting from a guy who just has one house and that's it, he's probably gonna be able to get away with fair housing violations. It used to be a landlord with more than 4 units. There are also some exemptions. If the landlord lives in the rental, they can use this discriminatory conduct or if it's senior housing, they can have specific housing for seniors. Religious housing, obviously, that's protected, and single-sex dormitories. So none of these, all of these are exemptions to fair housing rules. So if there is a fair housing violation, what can you do? You can ask for an informal negotiation with the landlord. You can bring it up if the landlord tries to evict you later. You can file a claim against the landlord. You can do that by filing a claim with HUD or suing them, or calling the Arkansas Fair Housing Commission, who will investigate your claim. And if you do any of these, anything you do, you have the right to be represented by an attorney the whole time. Okay, now we're going to talk about evictions. So to be legally evicted, your landlord has to file under one of three different things. There's unlawful detainer, and this requires that you pay the alleged due rent into court registry. That can really be bad if your landlord is saying that you owe like $1,600 back pay in rent. You have to pay that into the court before you can defend yourself in court. It's not really fair. There's also the 2007 Act, and this is limited to certain situations. And then there's the criminal fail to vacate, and this is a criminal proceeding in district court. And this actually doesn't recover property. It's basically the judge scaring you into moving. One thing I'm seeing a lot of in my practice, especially in the last month or two, are self-help evictions. These are illegal. It's very important to know this. The landlord cannot kick you out without a court order. They have to have something, a writ of possession, something saying that you have to go. They can't just call the police because they gave you a handwritten notice to vacate 3 days ago. Things that are illegal that are considered self-help evictions are the landlord changing the locks on you, the landlord removing your belongings and putting them in storage or out in the yard, the landlord shutting off your utilities, the landlord removing the front door, which has actually happened. All these things are illegal, and even if you're behind on your rent 10 months, if they don't have a court order, they can't do any of these things to you. All right, and now I'm gonna wrap it up by talking about the CARES Act, since I talked about evictions. There was a lot of confusion about what the CARES Act does and who it protects. At first, everyone was saying there was an eviction moratorium, and that was not true. It only applies to housing that's funded by the federal government, like HUD, USDA, Section 8, things like that, or federally backed mortgages like Fannie Mae, Freddie Mac, the VA, the FHA. So those are the covered properties. Those are the only people with any protection from the CARES Act from evictions. Another thing is the moratorium on evictions only applies to non-payment of rent. So if you're in a HUD-funded multifamily house and you're being evicted because you're too loud or your neighbors are complaining about you, they can still evict you for this. CARES Act only helps for people who are evicted for non-payment. The CARES Act moratorium ends on July 25th, 2020. We'll see if that's extended. If it's not extended, you still owe that, well, whether it's extended or not, you still owe that rent. If it's not extended, you're going to owe all of the rent you haven't paid on August 1st. And you can be evicted for non-payment after July 25th. So that's something I'm afraid we're going to see a lot of evictions for, but just keep that in mind if you're protected by this now, that those protections are going to end and you'll owe all that back rent. So if you need help, you think you might qualify, call the helpline, 1-800-950-5817. You can apply online at arlegalservices.org /apply online. If you have any questions about this presentation, you can email me. I'm h.newberry@arkansaslegalservices.org. And then we have future presentations where we're going to talk about different stuff. On June 29th, we're going to talk about record sealing, criminal record sealing, and public benefits. And on July 13th, we're going to talk about family law and something I can't remember right now. So are there any questions?